Hey,
Hey,
everybody.
chat. Good to see everybody in the building. We are calling this the Appellate Cleanser. It's a play, of course, on appellate and palate. And I think what this will be, maybe we could do this regularly, Jim. We do a round robin where we watch and or read different appeals and maybe post-conviction relief, anything of that sort. And it gets us away from the hard facts of the case, the sad stuff. And we just get to hear a lot more of the legal arguments and, from different perspectives, different issues. Today, we'd be looking at a Tennessee Court of Appeals, but this could really be any appeals court anywhere. So let us know what you guys think. And Jim, anything to say before we get into this case?
Not specific to this case, but this is one of the fun things. I'm sure many people know this, but that's one of the fun things about doing appellate work, either criminal or civil, is you have a fixed set of facts. You don't argue what the facts are. It's just purely the application of law, which is really fun. And one of the things I enjoy
And Nick
about
is
appellate
here
work.
too. So, love, we're going to have some
Here we
sweet
go.
perspective on appeals here in the United
Mm.
States. Always love it.
Yeah. Hey, folks. And I just learned that David Gingers have written a reply to the trustees' motion to exclude him from representing Laura Owens. And he's not a good lawyer.
How do you pronounce his name again?
Ginger ass. So it's my Swedish pronunciation. I have very. It's just hard. Yeah. Yeah. So David S. Ginger ass in the Laura Owens case, the serial pregnancy scammer, in the bankruptcy case now. He wants to represent her despite being a possible witness, which the trustees said, no, you can't. So they wrote a motion to no, tell him to fuck off. Well, not with more words and more lawyerly. And now he made how many pages of a reply to this? Well, it's a short one. It's only 9 pages long.
Wait, how long?
9 pages in the reply for being excluded as representing Laura Owens in the bankruptcy case. His limited scope. He only wants to represent her for 60 days, but with the option to either fuck off or stay in. That is what he is asking the court.
Yeah. So we're joined by Tiffany, my BFF.
Hey!
Yes, Tiffany, the Fit Lawyer ATL, good to see you. I did drop a link in case you want to pop on and watch with us. No pressure. Quick housekeeping, you guys. We just came over from a stream that was hosted over on Nick's panel where we talked and decompressed over the Edric Faust verdict. So if you missed that, definitely check it out. This is kind of, getting us away, getting us, a little bit of reprieve. Before we do that, I do want to mention that it seems like Colin Miller, you guys have heard me talk about Colin Miller when I talk about wrongful convictions and appeals. He often is how I hear about different cases. A lot of people know him for his work with the Undisclosed podcast for the Adnan Syed case. Caitlin Conley, a New York case, probably another case that's kind of up there on the radar that maybe you've heard about that Colin Miller has worked in some manner. He is taking an interest and he's reached out. He's interested in doing some pro bono work for Edric Faust. With that being said, I'll drop his Twitter link in the chat there. So we'll follow what he does, but we don't know exactly what's going to happen next. And a lot of people are asking about fundraisers and how do we send money over. And of course, I'll share what comes along, but just to answer some of the major questions that are out there, it's a bit premature to just put a collection bucket together now because we don't even know who the council is going to be, what initiatives are going to be taken next. But other than that, I think that's my checklist of housekeeping on Edric Faust updates.
Yeah, I mean,
again, we just did the panel over on Nick's.
A little more tomorrow. Tomorrow's Thursday, right?
Yeah.
Sorry, so since I left the working firms, I don't know what days are anymore. But yeah, Sunday's tomorrow, so we'll know more tomorrow. I mean, the sentence is going to be life.
Yeah, without parole. I don't think there's a possibility of parole on the table there. So,
but we'll probably get a better idea on motion for new trial. I assume we'll file that within a week or so, and probably amended one after that.
And perhaps an announcement of if Cruz withdraws to allow an ineffective assistance of counsel claim on direct appeal. You might hear that right at the sentencing hearing. So, so there we go, guys. And also, Trikisha over celebrating on Jim's channel 5 months since doing the YouTube things. So good to see you. And everybody, wherever you're watching, hit that like button.
Oh, is it on my channel?
Yeah, I have a paper clip, so it's coming from you.
Oh, I should. Okay, sorry. It's only been 5
Jim
months.
is so new to this that he
months.
doesn't even realize he has members and monetized.
I know I have members. I just,
But the surprise on your face that you have. Oh, it's mine.
There we are. Okay. Hey, everybody, in my channel, Mary, Trey.
Yeah, you gotta look for. I think you guys see the paper clips, or I see the paper clips for yours, and you don't see paper clips for your own, something like that.
We need more Tiffany Adams streams, by the way. I love Tiffany.
Yeah, I sent a link. If she wants to come up anytime, you can come up anytime, Tiffany.
Yeah, for sure.
This case, guys, I don't know any background. I started watching it a little bit, and I was like, oh, I think this is a case that reminds me of Jim. You guys will see why as soon as we start playing it. We're just gonna.
I look like the guy on the left.
No, wait, with the glasses. But we're going into a blind, but we get to hear the arguments and figure it out together. So here we go. You guys do volume check in the chat, and let's hear what they've got.
Good morning, Your Honors. If it please the Court, I'd like to reserve 2 minutes of my time for rebuttal argument.
Certainly.
Thank you. And may it please the Court, Joshua Hedrick here from Knoxville on behalf of Demetrius Bennett. Demetrius Bennett's convictions should be reversed for 3 reasons. First, it was error to admit proof of a possession of a different gun on a different day. And second, in the alternative, Mr. Bennett was deprived of the right to counsel where trial counsel failed to object to the admissibility of the gun. And third, that the evidence in this matter was insufficient as a matter of law. And I want to focus on the first 2 points today. I'd like to begin by the discussion of the possession of the gun. I know that Your Honors are likely familiar with the basic facts, but in this case, there was a lady, Ukiah Pelcher, I hope I'm saying her name properly, who claimed that Mr. Bennett was in possession of a black and brown gun. That's page 36 in the record.
I hate when people do that. Just pick a name, decide the way you're going to say it, and then just say it. Yeah. Because the judges don't know it either. It's just say it. It seems like you're making yourself sound unprepared.
Not everybody can blame their accent like I can.
Just pick a name. I hate that. It doesn't matter at all.
And that tie should be either a shade lighter or a shade darker. Now, folks, you have seen me in many, many types of clothing on my show. When I'm at work, I'm spotless.
That tie should be spotless. It's got too many spots.
Is it like that radio frequency? Yeah.
I could change. We could make him sepia.
This looks like some crappy true crime show from 1990 when he turned it up like that.
Oh, Lord.
Now
I've never used that feature. I always wanted an excuse to use it, so I just jumped at the chance there. All right, guys.
All right. We made it 4 seconds before I had to go on some dumb tangent.
And the state sought to introduce a video of Mr. Bennett in possession on a different day, separated by several months, of a black gun. The trial court observed, both in the record at 55 and in the written record in Volume 1 at 64, in the trial court's opinion relating to the motion for new trial, the trial court observed that it may or may not have been a different gun. And I say that because the trial court sort of takes both positions respectfully. The trial court accredits the strategy of drawing distinctions between the weapons, but then the trial court specifically says that the video of the gun from the prior date was relevant to show that he possessed the same gun on this date. So inherent in that, I think, is the trial court making the finding that it is the same gun, because the trial court says there is relevance in it being the same gun.
How did the trial court instruct the jury that they could view the gun, view the video?
There was no limiting instruction given. The video was presented to the jury, as the record seems to indicate, sort of without comment. The difficulty was, and I will tell Your Honor that.
So the trial court didn't instruct you can't use this video for propensity or anything like that?
There was the date there was the different date, right? That the indictment charged on this date, and the instruction said you must find he was in possession of this firearm on this date. And the record indicates that the video was clearly a different date. I think it was July and September was the time span. But if I'm incorrect, I'm happy to be corrected. But my recollection of the record is that there was no limiting instruction. So the problem becomes compounded by the verdict we have in this case. And the difficulty that we have is Mr. Bennett was charged with aggravated assault, he was charged with reckless endangerment, and he was charged with possession of a weapon by a felon. The jury rejected the aggravated assault in favor of, they acquitted on aggravated assault and convicted on simple assault. The jury acquitted him entirely of the reckless endangerment and then convicted him of being a felon in possession of a firearm. Now, the testimony at trial from Ms. Pelcher, who was the only...
We don't have to have consistent verdicts, do we?
So the inconsistency is not automatically a problem, and I'm not advancing the argument that I recognize that the law is we do not have to have consistent verdicts. But I think we can learn from this verdict is that the jury appears to have considered something that they should not have. And by that what I mean is the jury appears to have rejected the idea that Mr. Bennett brandished or threatened anyone with a pistol on that day.
You're asking us to jump into the mind of the jury. We have no idea what we're thinking. That's one of the reasons we say that you can have inconsistent verdicts, because there's no way for this court or any court to determine what they were thinking, why they did what they did. As long as the evidence supports the verdict they returned, we're not to question why they came up with the random verdicts that they may have come up with.
So is there anything in the record that supports what you're advancing to us, that the jury considered the wrong date?
Respectfully, I think so. Although you have to reason from what is not in the record. And
well,
if I may,
then that gets back to Judge Dyer's issue. You're asking us to speculate about what the jury did or didn't do.
I don't think I am. And the reason I say that respectfully is there is no testimony that he committed a simple assault. There's no testimony that he touched her. There's no testimony that he placed hands on her. There's no testimony that he threatened her other than the phrase, "I'm going to shoot you." So the only way you can get to simple assault is if you entirely reject her testimony.
Sorry, stuff.
And if that's so, then the only pistol that you have in front of, the only proof you have...
I need to clip that. There's nothing except I'm going to shoot you. Yeah? Now, I understand him. That in itself is not evidence that it actually happened, but it just sounded so funny.
Well, and it's because he's talking about simple battery rather than aggravated assault. So aggravated assault can be supported by the threat, but simple battery is not supported by the threat, and that's simple battery has to be offensive, like the touching, an actual physical contact, whereas aggravated assault can be the menacing threat, you show a gun. So that's really the distinction he's getting at here, but colloquially, it's very funny to hear somebody say that.
Yeah, we gotta hear that. Somebody said positive QB said replay, and I think we have to.
Yeah. Let's get back. Let's start from her.
I don't think I am, and the reason I say that respectfully is there is no testimony that he committed a simple assault. There's no testimony that he touched her. There's no testimony that he placed hands on her. There's no testimony that he threatened her other than the phrase, "I'm going to shoot you." So the only way you can get to simple assault is if you entirely reject her testimony. And if that's so, then the only pistol that you have in front of, the only proof you have of a pistol's existence is the video from the prior date.
And I changed my mind. So it's both of them are assaults. And neither of them are battery, right? I thought he said simple battery at some point. But assault, a threat, a verbal threat. If someone is reasonably in fear because of that threat, then ignore my argument from a few minutes ago, and I thought he said battery.
Except I'm going to shoot you. It's like hearing this. I'm not this, and then but. Oh wow.
Well, but see, this is interesting. Amanda Lives, pin this. And this is the heart of what he's going to argue here. So there's a video that the state introduced, and it's going to go down a rabbit hole, but the video introduced is from a totally different date. It is not from this incident.
It's
months on one hand,
prior.
it's prejudice. It's a prejudice issue, introducing this at all. Additionally, it might not even be the same one. So that this is going to come into play.
That's such a wild sentence. I get it, but it's still.
Yeah, I understand this argument, but it just sounded so funny.
And I guess maybe the idea would be if you take that testimony about that threat to be credible, the jury would have found, they wouldn't have found for the simple. They would have gone higher.
Yeah, but again, any evidence that she knew that he was seen with a gun? You have to take that into, if she's not in the video where he's handling the gun, then what evidence is there except her testimony?
Nick, I think you're gonna like this one, Nick.
Oh. Okay.
And that is where the problem is. That's where the prejudice is shown by the admission of that previous pistol, right? That the difficulty is that by presenting this inadmissible evidence to the jury comes to the conclusion that there was a gun, when we know the jury has rejected the concept of there being a gun. The jury has said in the aggravated assault count, there was no gun.
That's not what that necessarily means, though, because we don't know why they rejected that count. That's the point. I mean, I get your argument, right? Mm-hmm. That the aggravated assault is based on the weapon.
Look at all their faces.
We don't know why they rejected it.
Well,
we don't. I mean, for all we know, there was a juror in the back that said, "I just refuse to do this."
I think we should, but we have to. Don't we have to presume that the jury followed the instructions? And if we presume that the jury followed the instructions, then they would have gone through.
The jury can follow the instructions, yes, but all you could have is one juror to say, "I don't believe there was a gun." One. Mm-hmm. You could have all the rest of them saying, "I believe there was a gun," but since they couldn't reach a verdict, they went to the next count. That would be following the instructions.
But we know that's not true here.
But also,
because they
jury,
convicted.
Let me ask this question. If the jury followed the instructions, you said earlier that they were instructed that the possession must be the September date, not the July date. So, I mean, you can't have them follow one set of instructions and it's okay to not follow the other. I mean, were they or were they not specifically instructed about the possession on that specific date that was charged in the indictment?
So that's the problem, is that if the jury said, as Judge Dyer said, if the jury said, if there's one juror who says, "I don't believe there was a gun," then that would be okay, but we know that didn't happen because
how do we know that?
Because they unanimously found he did have a gun. They unanimously found that he had a gun on this date.
On that date, not the prior date that was shown in the video.
Which is the difficulty, right?
I understand, but they were instructed it was on that date.
But they cannot. So the only way that they can find that gun exists is if they reach two different decisions on the different counts. Right, which is an inconsistent verdict, but in a case like this where you have the potential, right? We have to prove on appeal that the admission of the previous video was an error, and that error prejudiced a substantial right, And in this case, the prejudice is shown by the fact that the jury reached different verdicts. Maybe it's helpful if we don't think about them as inconsistent verdicts, but if we think about them as different verdicts, that the jury reached two different decisions about what happened here. And the only way to do that is if they gave impermissible
It's a better way
weight
to put it.
to that prior possession.
But that's, and I think this is, and I,
Do you guys have the feeling like this is like a tennis match? Like usually either we're watching one side, the panel doesn't ask any questions, and here it's like as soon as one of the justices is asking a question, I'm like, oh, that's a good point, that's a good way to constrain it, and then he responds and I'm like, oh, okay, so we're back to the argument making sense again. And it's just like, for me, I'm like shifting back and forth a lot, and I enjoy that. I don't know what you guys think.
Yeah, I think it's a good argument. I'm really excited to see how critical they are of the state in this case.
I didn't get that far.
I didn't.
I got to this and I was like, we've got possession, we've got a video, we've got jury saying it wasn't the top charge, but they think that he had the gun. I'm just gonna tell Jim.
I understand your argument, but I think this is exactly why the law says that put it simply, there's nothing we can do about inconsistent verdicts. There's nothing wrong with inconsistent verdicts, because while you're making a great argument, your argument's completely speculation. And the state, when they respond, their argument is completely speculation, because no one knows what took place in that room. And no one knows why they reached the verdict they reached. And so that, in a very simple form, that's why we have to say, the law says, inconsistent verdicts, there's not much you can do about them.
And in that, so that, I think,
unless there's just not proof to support it, unless it's just not sufficient. Like if they find a verdict, they find it and they say it's, and you go, well, looking at the record, there's no way they could have found it because there's no proof of it. That's different. But here, there's proof of a gun, there's proof of an assault. Just because they didn't match the two to an aggravated assault and a possession of a gun, we don't know why, but they didn't. But there's proof for both of them.
And what Your Honor's highlighting, I think, leads us into the second issue, which is, what you're highlighting is the reason why it was so harmful for trial counsel to not object to this, because by not objecting, we have created this issue. So
I don't want to move you off of your inconsistent verdict issue, but since you just brought it up,
What?
you've now raised an ineffective assistance counsel claim on direct appeal.
yes.
And I guess my first question to you is, does your client understand that now is going to limit at some
Yes.
level his post-conviction
Yes.
should you not win this appeal?
Correct.
Okay.
And so to that end, the trial court,
I think Georgia kind of works in the reverse. Like Tennessee says, if you raise it at the Court of Appeals rather than in a post-conviction relief petition to the trial court, you waive it. But I think in Georgia, they expect that you raise it if you file at the trial court, that you raise the issue there first, and then you can only get around it and raise it at the Court of Appeals if there's like new information or like something that you just get put on notice. Or I think new counsel, new counsel can do it.
Yeah, basically, you just have to raise it at the first opportunity, and
like 99% are gonna make the first opportunity
usually
the
it's
trial court.
If you get new counsel, it'll be motion for new trial, but generally they don't like it when you can't really argue that they generally don't let you argue that you're like, if the trial attorney can't argue that he himself was ineffective on a motion for new trial, they generally don't allow that. But otherwise, it's at your first opportunity.
I would love to watch that. I wish they allowed it just so we could watch them say how much they suck.
But yeah, it does have to be on direct appeal, as opposed to if you don't raise it on direct appeal, it is defaulted for habeas petitions. You can't raise it again unless there's new information, like you said.
Well, and then the interesting thing with that is if someone's dealing with state and federal charges, most states, a lot of states, as far anywhere that I've looked at appeals, states give you like one bite at the apple when it comes to raising a habeas petition. But if you're a federal prisoner, Supreme Court has said, no, we don't look at it the same way as states. You can have more than one effort. So I think it's just so cool how things are different in different areas.
Yeah, federal, they'll usually do like a less in-depth review. Basically, just want to make sure that you
There's
weren't
some
totally.
merit.
Yeah. State habeas, you generally get a little bit more depth.
Sweet. Good stuff.
Trial court, in finding this, so the issue, of course, is how did we get to this argument that we're having right now? And that is because trial counsel failed to object to the prior gun. The prior gun, as we know, the case law is plain, that possession of a different weapon on a different day is not relevant evidence. In addition to a 404 issue, it just simply isn't relevant, right? And in this case, trial counsel explained that he did not object because he had a strategy of showing the jury that the guns were different, right? Now, that strategy was
a bad strategy?
Moronic.
The trial court
Unreasonable?
makes somewhat of a confusing ruling because the trial court rules that strategy was reasonable and then rules that, and I quote, the evidence was very relevant to the material issue of whether the defendant owned
after you got it denied.
Yeah, it's not an either or, which is kind of what the trial court is saying. You can just just object, and then if they say no, then you can argue.
Yeah.
the
Strategize
second
it.
point. Yeah.
Yeah.
same firearm around the time of the alleged offense. And that's in the record at 64, in the written ruling. And so the trouble is that the trial court has found, the factual findings of the trial court are problematic because the trial court has found that it was a reasonable strategy to argue the guns are different and the guns are the same. And so if the guns are the same, then it is not a reasonable strategy. And I'd suggest to the court that the strategy of comparing the guns is inherently an admission that he had guns. If you're saying it's a different gun, you are conceding the felon in possession. That is respectfully, not a sound and sensible trial strategy, to concede the felon in possession.
So I think this was kind of masterful. Like the argument he just made is plain on its face, but I think what he's doing is masterful because he's using the trial court's ruling to say that it's not sensible. Because the trial court's like, it's clearly the same gun, and this defense attorney just wanted to argue it was two different guns. For whatever reason in his head, thought would be compelling at trial.
Yeah.
So you have the trial. He's relying on the trial judge making.
Yeah.
Yeah.
And I liked how oh shit, I'm losing this type. And the switch over to the next argument, that was good because he was clearly losing the other one. Yeah, let me move on here.
Yeah, I think that was particularly bad because the judges were like, yeah, if this is really smart, we love this argument. It loses, but you did a really great job of making this argument.
The surgery was successful. The patient died.
The kiss of death, exactly.
Oh my goodness.
It is a better strategy to have the jury hear about fewer guns. Because that's what we're saying, was it a reasonable strategy to tell the jury, hey, that gun, he had a gun, he just had a different gun.
Let's run this back in full because I think it'd be great in full.
He's really good.
Of comparing the guns is inherently an admission that he had guns.
Yeah.
If you're saying it's a different gun, you are conceding the felon in possession. Yeah. That is respectfully, not a sound and sensible trial strategy, to concede the felon in possession. It is a better strategy to have the jury hear about fewer guns. Because that's what we're saying, was it a reasonable strategy to tell the jury, hey, that gun, he had a gun, he just had a different gun, is not a reasonable strategy when compared to the strategy of saying, we should not tell the jury about the other guns he has. That's not a sensible trial strategy. And it It's seen in the jury verdict because, as we have discussed at length, the jury found him guilty of being a felon in possession, and I would submit to you that that was in part because of trial counsel's strategy of saying, yeah, it's a gun, it's just not the same gun. That is not a sensible trial strategy.
They're not going to
There is not entitled to that deference, especially when the law clearly establishes that this is not relevant evidence, that there should have been a 404 argument. It is a little hard to tell from the court's ruling whether the court found this was a different gun or not, but that issue should have been raised. That issue should have been raised because it is the only reason that the jury heard about this other gun. The only reason we're having this debate about the inconsistent verdicts is that the jury was told about guns it didn't need to hear about. And on a trial strategy of I did the crime. And that is not a sensible trial strategy and should not be entitled to deference. And for that reason, there is a...
It's from the back. I think there's a channel emoji for that still, courtesy of Woody.
That issue should have been raised because
isn't a valid legal defense. He's really good at like simplifying these things down to their like barest, most minimal principles.
Yep.
In a really funny way that wouldn't be funny in the same room, but watching it from afar, it's really funny.
Yeah, I think it's because the camera's right on him. Like, if you're sitting behind him, it probably wouldn't have the same effect. Oh man,
he's really good. He's a really good lawyer.
Yeah, I'm enjoying it, and I think it's interesting to watch an appeal that's not a murder case.
Yeah,
yeah. It's a nice refresher.
Can you imagine this guy
nobody died in the commission of this crime.
Yes. It was just a threat. It was only a threat.
It was just, I'm going to shoot you.
Did he say, I'm going to shoot you with this gun? Maybe.
We need to find the trial. This is probably like a one-day trial. We need to find it.
Oh.
Oh, wait. His name was probably at the beginning, maybe? All right, where are we? We're 1422. Let's see if he reads his name.
Good morning, Your Honors. If it please the court, I'd like to reserve 2 minutes of my time for rebuttal argument.
Okay, you didn't say his name.
Thank you. And may it please the court, Joshua Hedrick here from Knoxville on behalf of Demetrius.
Joshua Hedrick. All right, we were here.
The only reason that the jury heard about this other gun, the only reason we're having this
in Georgia. There's an appellate attorney named Ashley Hedrick in Georgia. I was trying to remember where Hedrick came from. State AG's
debate about.
I keep thinking that it rhymes with Edric. I'm supposed to take our focus off of that case, and then his name rhymes.
Because it is the only reason that the jury heard about this other gun, the only reason we're having this debate about the inconsistent verdicts is that the jury was told about guns it didn't need to hear about. And on a trial strategy of I did the crime. And that is not a sensible trial strategy and should not be entitled to deference. And for that reason,
that's a good point.
There is a probability of a different outcome. And that probability of a different outcome is sufficient to undermine our confidence in the outcome. That we cannot be confident that this outcome was a fair and just outcome and that it wasn't based on this unacceptable evidence that was admitted on respectfully a poor strategy. And it doesn't give me any pleasure to be critical of another lawyer's trial strategy, but in this case, it is impossible to see a path by which that argument results in the jury finding your client did not possess a handgun.
What other proof in the record was there of the defendant's possession of the gun in the charged count other than the victim's testimony?
The only proof in the record was her testimony. And that's why I think the jury's rejection of her testimony is important. That's why I leaned so heavily on it in my first issue, was the jury's rejection of her testimony, because there is no... The other testimony essentially was that the officers arrived and they located Mr. Bennett and they arrested him. There was not a weapon recovered The only source of proof of the existence of the weapon was Ms. Pelcher said she had seen it or had been threatened by it, depending on how you would credit her testimony.
So that, to me, that's a critical fact.
Mm.
They show up, they arrest him, and they don't recover a firearm. So
Yeah. How close in time was it? Is it a week later? Is it an hour later? Was it in his car?
Yeah, it is.
did they just not search him well? I don't know if you guys heard, like a few months ago, there was a woman that was in the back of a patrol car, but the officer, it was a girl and it was a male officer, and he didn't search her. He didn't know that she had a little revolver on her, and she ended up shooting him from the back seat of the patrol car.
Oh, I thought you were going into the Acorn cop.
Oh no, that's another.
Yeah.
That was a time too, a separate time.
Yeah,
But they don't always find the firearms when they take
Yeah.
somebody. So.
Women have more hiding spots than men.
Well, and he might have been like less stringent in searching, maybe, I don't know, but
Yeah, there's a if Matthew's here, he'll know where it was, but there's a case where the police just left a woman in the backseat of a cruiser, and apparently there was a gun like within arm's reach. It was the cop's gun, and she just took it and essentially held the Sallyport hostage because all of the cops' guns were also in the Sallyport.
Oh,
And so they couldn't get to the guns. I was kind of drunk when I watched the
was
body
this
cam,
in
so-
Canton? Was this in Canton, Massachusetts? They are known to forgetting their
lose
guns
their
in their
guns,
cars.
yeah.
Who among us
Hilarious.
hasn't?
Who among us haven't forgotten their gun in a cop car? I mean, it's so easy to forget.
Oh, man.
Oh.
Yeah,
Okay.
so for the facts in this case, what he's representing here is that when they arrest the appellant, they didn't recover a firearm.
Yep.
And he was convicted on the possession charge. It was an inversion.
So in that case, there's a clear difficulty in saying that there's no probability of a different outcome, and for those reasons, we submit that the judgment should be reversed, and that he should be entitled, at least at a minimum, to a new trial based on these errors with respect to the admissibility of the evidence. I appreciate the court's time. I think I'll save the remainder for rebuttal.
Ooh,
if that's all
fancy.
right.
Thank you.
They have their
May it
own
please the court,
swoops.
Catherine Redding on behalf of the state. I'd like to just quickly clarify a few points on the facts of this case. The state's position at trial was that the gun in the video and the gun at the Taylor homes were the same gun. And as I understand the record, defense counsel was of the same opinion. I think that there is some confusion because in the trial court's order denying the motion for new trial, it seems to have misheard or misunderstood defense counsel's
this is a bad
testimony at the
start,
motion for new
Catherine.
trial.
So the judge had material facts wrong that neither party had an issue with.
Well,
Okay.
credit to her for straightening it out.
Owning it. For
Yeah.
owning it.
Yeah. Not a good fact, though, to own.
Right. If you guys missed the panel over at Nick's show, Doug was just talking about this. Oh, that it's always good when the state gets up there, and if there's an issue, just own it.
Yeah.
Hearing, defense counsel testified that he had a strategy that he wanted to say. He didn't object to the video because he wanted to say at trial to the jury, Ms. Pelcher is lying. She never saw a gun at Taylor Homes. She had saw that video, and Ms. Pelcher is the defendant's ex-girlfriend. She saw that video, and I mean, the closing argument is in the record in this case. And what counsel said was, Ms. Pelcher is lying. She never saw a video at Taylor Homes. She told the police that she described the gun she saw in the video to the police and said that that was the gun the defendant had. But there is no proof that the defendant actually had a gun at Taylor Homes. He also suggested to the jury that Ms. Pelcher was responsible for sending the video to the defendant's probation officer. So the defense theory was
doesn't really make
Ms. Pelcher
sense.
lied. She was upset with the defendant. She had sent this video to probation and nothing happened. And so then when she saw him at the Taylor homes, she called 911 and said she saw the gun, and it was the same gun from the video. So I think the trial court seemed a bit confused about defense counsel's testimony. So I think that's where some of the confusion comes from. But the testimony at the motion for new trial hearing,
She was like a
and
remand
then
at least.
What's going on
Look,
here?
she's like, do I really have to go through
Look at her
all
face.
this?
Yeah.
Look at her face.
Yeah. I'm sorry I have to say this, but
Yeah. We should take a screenshot for the memories. We'll make a scrapbook of our.
I like her. She's
yeah,
she's laying her cards on the table.
she's very, very honest.
The trial
She's more or
judge
less
is
saying
confused.
the judge was kind of stupid.
I reserve my right to change my opinion if she says something that I don't like.
Always a rule on this channel.
The arguments at trial all indicate that both the defense attorney and the prosecutor were arguing it's the same gun, or that the gun in the video matches the description from the Taylor homes. So just to clarify that point. So
Would that be a reasonable strategy of trial counsel then, to not make some kind of objection to keep it out if it was the same gun? That's even more propensity type evidence.
Exactly.
well, that was the so it gets to the ineffective assistance of counsel claim. It's the state's position that the defendant is not entitled to relief on that because trial counsel made a reasonable strategic decision not to object to the video of the
Okay,
gun.
yeah, that's the
As
question.
I've
That's the
said,
question she just asked you.
counsel,
I don't
his
like her
whole
anymore.
argument was Ms. Pelcher is lying, and he
That's
relied on
relevant.
the video.
That's separate and apart from the video.
Yeah.
If you don't have the video, you don't even have to make the argument.
Yeah.
That's right.
And
Armin.
Yeah. If
Like
the
they-
video's out, the gun is not in evidence.
So
You don't have to.
no,
Oh,
go ahead,
no.
Nick. I was gonna say they moved on. The appellant moved on to the second argument, and the judge was like, "Okay, we're interested in this one." And then the state now gets up there, and then they're like, "Hold on, now that first argument was good."
Oh, you're saying the judge got that wrong? Oh, no.
Oh my goodness!
Now we understand what he was trying to say.
And
Yeah,
all
quite-
stemming from the state, like, and it'll relate to something we're going to watch after that I've already read ahead of time, but the idea that prosecutors are for the people, so they should want to, it could be on their table to say, hey, look, this other video from another point in time could be prejudicial. They could have had the discretion to not even bring this video in and just argue everything else as the facts.
Mm.
Like, and we wouldn't be here. We wouldn't be here, at least for this issue.
Yeah, and I think it gets back to his funny little catch line about like you want less guns in evidence, not more guns
Yeah.
in evidence.
Especially if you're already a felon, having
Yep.
a gun in evidence is quite damning. If the charge is possession of gun and you on video have possession of gun.
To offer an explanation of how, we have a 911 call from Ms. Pelcher where she is immediately calling 911, and they're like, well, what happened? What did you see? And she, oh, the defendant has this gun, and gives it automatically, is just rattling off a description. And so counsel relied on that. And I think that it was the state's position that was a reasonable strategic decision. Ms. Pelcher's testimony was the only, as defense counsel has said, it was the only proof of the offense. And so the way to a reasonable decision on how to present a defense is to attack her credibility. And counsel, this was part of counsel's strategy. But even if this court were to disagree and find that counsel was deficient for failing to object, the second issue is that the defendant can't show prejudice because he can't show a reasonable probability that the trial outcome would have been different had counsel objected to the video. And so this state's position that
Curious to see where you're going with this, but okay, let's proceed.
let me not even speak my mind. Maybe my facial expression made it clear.
The trial court, that there's no breach of a clear and unequivocal rule of law by admitting this video. And
That's separate. That's a different issue.
that it is that the defendant can't show a reasonable probability the trial
Yeah, she
outcome.
just switched to error of law
Yeah.
when she was just making an argument about it wasn't harmful, there was no prejudice to the appellant.
Like, of course
Right.
it's prejudicial.
Like the only other thing that we've heard is that they did not recover a gun. So if we don't have this video showing this guy with a gun, albeit on a different date.
Yeah, I mean, essentially, she's saying that like the defense wouldn't have been able to say that what's her name? I'm doing the thing that I said you shouldn't do, and Pulcher, whatever her name is, wouldn't have been able to lie about a gun. Will lie to describe a gun unless she had seen a specific picture of a gun previously. Like, people know what guns look like. It just doesn't make any sense.
Yeah, and unfortunately she just said rattled off exactly what the gun looked like, and we don't know what that description is based on her recitation of it. And honestly, if it was too specific, that would be a credibility issue for me if you didn't like you were trying too hard to know what to say.
The trial court would have excluded this video. But even if the court had granted the motion, had excluded the video, the defendant still can't show a reasonable probability that the trial outcome would have been different, because we don't know exactly what the jury was thinking, nor should we try to inquire into their deliberations. But what we have is Ms. Pelcher, the only witness testifying she saw the defendant with the gun. We have a jury showing with its verdict that it found her credible because it did find that the defendant had a gun.
Yeah, because of the fucking video. Sorry.
The verdict would have been different if they had to have the gun, because they found that he had a gun. So obviously that means they would have found that he had a gun no matter what happens, because they said that he found a gun because he had a gun. What? What are you doing?
Well, and they didn't think she was credible enough to really like the verbal threat was I'll shoot you or in the face or whatever it was, but they didn't find that was the aggravated assault. They just found simple assault. So I think that is going back to what her laying this out makes the first argument of Hedrick of Hedrick make more sense. Oh boy.
Of assault and 2 counts of unlawful possession of a weapon and evading arrest. The fact that the jury declined to return guilty verdicts on all of the charges does not necessarily mean that the jury found her incredible. I think that this is a case, and the court will have the record, but it is more likely that the state just didn't prove aggravated assault.
Did the court give any instruction on how they can view the video versus the testimony?
So I don't recall a contemporaneous limiting instruction, but we do have an instruction to the jury during closing the final instructions, where the court told the jury that the state had to have proven beyond a reasonable doubt that the defendant had been set out the elements for the unlawful possession, but specifically says, just to be clear, we're talking about the date of September 16th, 2021 at Walter P. Taylor Homes, not the video. So
that's not the instruction that would be relevant here. Would you even argue this if you I mean, I guess she was asked.
I mean,
but like
she's the state, so yeah, she has to argue it.
I mean, he's clearly asking, was there any instruction given like, hey, you're not supposed to consider this? It's the typical for propensity, bad character, prior, that type of instruction. You should only be I forget how exactly they word it, but I think every state has their own little model instruction. Not a, hey, we're these are the elements of the information, the indictment that you're asked.
And if you don't have the video, you don't have to do that at all. Just kind of sidesteps the whole issue.
16th, 2021 at Walter P. Taylor Homes, not the video. So there wasn't this, you can't consider just because he had it then, he had it now, but it was very clear to the jury that in order to find the defendant guilty, he had to find
That he had the gun that day.
not that he had it in the video. And it was very clear to the jury, the video predated the offense date by several months.
That doesn't make it less
because the jury
prejudicial.
heard from the probation officer or supervisor that she received the video in either June, I believe it was June or July. And
All right, so as a layperson, it seems like she's trying to say that the credibility is there because she described a gun and defendant has had a gun before. But that's the very issue that it sounds like the trial court, maybe the confusion or maybe what he was trying to point out, and she's taking the argument as literal. I haven't seen the order. But the idea that somebody, it goes to, it could unnecessarily bolster Pelcher's credibility, because if you're accusing someone of having a gun, even if they're not found with it, if you show something where it shows they typically carry a gun, then you might say, hey, you might be more inclined to think the police just didn't find it. And you might not even think of that if this video wasn't admitted in evidence. So I don't see how that could be.
Yeah. Now, if
harmless.
the charge was only felon in possession, then this evidence would have been examined in a different way. Okay, is the timestamp correct? Is this before or after he became a felon? All of that stuff.
Or just prosecute him for the video.
Well, yeah.
The date of the video, I mean.
Yeah. But it seems like the trial strategy was, as they said, oh, he had a gun, just not that gun. Oh, no. You didn't even challenge the video?
Yeah, I don't get it.
The data surrounding the video, how it came into possession.
Yeah.
Yeah.
The more I think about it, the more I like the argument. Like, we want less guns, less gun video, less guns, not more guns.
I did these crimes is not a good defense strategy.
No.
Yeah.
Rarely. Yeah, I did it, but find me not guilty. I mean, that might be a lawyer slogan. Just because you killed somebody, you might not be guilty of it.
It's potentially criminal.
Yeah, I think especially in this case where you only have one eyewitness who apparently has some kind of history with the defendant. And then you're like, no, let's get the video of him doing the objective video of him having a gun into evidence.
Yeah, because it bolsters her credibility, and it's got to be harmful because that's the only other thing that they could have relied on.
Yeah.
So, because I'm assuming the officer didn't get on the stand and say, yes, we recovered a firearm, because they did not recover a firearm. So, Lord. What a time.
And it was also clear the offense occurred in September. So that was clear to the jury. And so it's the state's position the defendant has not shown both Strickland factors for ineffective assistance of counsel. And then going back to his attack, basically, just on the admission of the video, the defendant concedes we're up on plain error review. And I think the defendant has to establish all 5 factors, and this is a case, it's rare, but this is a case where we have testimony from trial counsel that they made a strategic decision not to object. And so this is a case where this court can find that the defendant cannot show that he didn't waive the issue for tactical reasons, because
How do you guys feel about an attorney saying that it wasn't ineffective assistance of counsel? About themselves.
Okay, like you can have, just because it is a strategic decision isn't the full analysis. You see this shortcut all the time. It has to be a reasonable strategic decision.
Yeah.
Like you can you can be just an idiot in your strategy. You can be like admitting that your client did everything.
And if you're an
Like, that's
idiot,
your
you're more
strategy.
inclined to say it was a good strategy. You're going to
Yeah.
continue
Folks,
maintaining down that
Daryl Brooks
pathway.
would have objected.
Yeah, it doesn't even have to be a good strategy. It just has to be like somewhere,
No,
and
no,
some reasonable attorney could make it, even if it's a bad strategy. That's
Yeah.
not enough. But just having a strategy doesn't mean it's not ineffective assistance. That's just a misstatement of the law.
now Darrell Brooks' reasoning behind it, the objection would have been interesting, but it would have still have objected against evidence coming in against him.
And then could have been ineffective because of the wrong legal basis raised. Moon Goddess says, could the jury have convicted him for having the gun based on the video, which was when he was then committing the gun crime, which I'm guessing if jurors did that, that's also an issue. So this is a two-pronged type of consideration here, right? So the information should give the time frame, the indictment should give the time frame, and then the judge at the end did recite. It sounded like the judge just read the indictment and included the date during the jury charges, the jury instructions. But the other issue here is that you're supposed to assume that the jury follows instructions. So for the consideration of these appellate arguments, all the appellant, the appellee, the justices, they should assume that that's not why the jury convicted. So really the analysis would be that video, the argument, that video made them more inclined, just for the sake of propensity issues, to convict on the possession of the date in question. So that's why they're making it the video itself shouldn't have been admissible, because it prejudiced the defendant as it related to that possession charge for the date in question. So it seems like a long way to get there, but essentially, yes. But they have to argue it a different way.
Yeah.
So I'm sorry, I'm covering Nick there when I have a longer comment. He's just a flower. Look at the
No
moon
worries.
goddess flower over Nick.
Yay!
Love it.
Have that testimony for counsel. But the state's position is, even if this court finds that that's not, disagrees, that he can't show the breach of a clear and unequivocal rule of law. The video was relevant because it showed that on the day prior to the offense, he had access to a gun that matched the description, made it more probable that he possessed the gun, but more important, he can't show that a substantial right was adversely affected. Evidentiary rulings ordinarily do not rise to the level of constitutional violations. Again, he can't show the tactical reasons, and he can't show that consideration of the error is necessary to do substantial justice, because, as I said, the jury heard that the video was filmed at least several months prior to the offense. It was aware of this timeline, and it was instructed that it had to find the defendant, if it was going to find the defendant guilty of unlawful possession, it had to find that he had the gun at the Walter P. Taylor homes, not that he had it in the video. And the jury's verdict demonstrates that it carefully considered the proof at the trial. It didn't just convict the defendant because it saw this video. It, in fact, declined to convict him of reckless endangerment and declined to convict him of aggravated assault, and instead only found him guilty of the lesser included of assault. Can
you help me understand? It's been a while since I've read the briefs, but you've got an indictment that charges this defendant with several crimes, all occurring on the same date at the same place.
Yes.
And one of them is ag assault, presumably based on him having a weapon, and the other is possession of a weapon.
Yes.
What did the defendant testify at trial?
No.
So then I want to know, the state has the burden of proving the guilt of these crimes on this date at this time. What was the theory that the state would use in trying to introduce a video of this same defendant with a weapon at a different time, at a different place, other than to show he has a propensity to go armed? I mean, I can't figure out how it wouldn't pretty much be a blatant propensity type evidence that, and I realize this thing about strategy and, well, we wanted to show it wasn't this, it was a different one, but how do you get to the idea of a video of a guy with a gun at another time prior to this, at another place? How do you get to how did the state get to what theory did they have to say
It's a long question.
this should come in to prove his guilt of these crimes on this time? That's what I'm having trouble understanding.
Sure. And I will admit that my recollection of how this video, I don't recall there being a hearing. I think that makes sense given that the defendant didn't object, so there wasn't a full 404B hearing where counsel for the state had to make an argument. It really just came in. And obviously the record will speak for itself. But
whoopsie.
I can't recall whether the state articulated a specific
I do believe the
reason
prosecution
to
has an
support.
obligation to only present evidence they know can have a chance of being admitted.
Yeah, I don't know.
Not based on trials I've seen, but in theory, only try to admit evidence that has a reasonable chance of being admitted. It should be, code of conduct, a reference to a code of conduct thing.
Well, you miss all the shots you don't take.
Yeah,
So
yeah.
I think that was the logic here, and it worked.
Yeah.
Because no one objected.
reason
Maybe the trial judge's order was because that was the only conceivable way the trial judge would think he didn't object. Even though that's not actually how it played out, but maybe just in the trial court's mind to make it make sense. They just assumed and took for granted what the strategy may or may not have been. I don't know. Yeah, the spaghetti method. Throw everything at the wall.
I guess the main reason I'm asking this is obviously the lady who testified that she was assaulted, and we've got some different interpretations apparently of her credibility by the jury's verdict, this, that, and the other. But he was convicted of, and I guess it's probably the most serious of the offenses, having a weapon as a prior felon or whatever that charge was. He was convicted of that. And so the weapon issue is a pretty important issue, and you sort of get to the idea that his argument would be, well, it sure bolstered the state's case to show, well, this is a guy in a previous video who had a gun, so he probably had one this day too, and it goes around with a gun. And so I'm back to the jury. They're going, well, we're not sure what this lady, we don't know if we believe her or not, but what about, did he have a gun? Well, I'm not sure about this lady's testimony, but we got this video of him going armed, so we got some pretty good proof here that he probably had a gun. In fact, we think he had a gun beyond a reasonable doubt. I mean, it's not much of a
Well, and I think this is getting to Moon Goddess's question. So
I like this guy.
Yeah.
He has no problem talking about what the jury might have done differently. And it's like, I think the state is trying to avoid the issue of thinking of what's in the jurors' heads, because introducing this would make different things be in the jurors' heads. And then they would have to admit harm. So he's not afraid of it.
Yeah.
Oh, yeah. You want me to screenshot the smirk? I'll screenshot the smirk. Let me move the caption. Maybe a new emoji. There we go. We'll get a new channel emoji. We'll get a panel of judges going. I'll send this to you guys in case you want it.
extra
I have
step
so many
there.
of George Simpson, so
Gotta get like a mosaic going. Build one ultimate judge with pictures of all the other judges.
yeah, I believe I have over 20 screenshots of George Simpson going.
Yeah, they get to be very, very obvious.
To convict him based on that,
I understand the court's concern. I think that this is a situation, though, that we have the limiting, not the contemporaneous, but we have the instruction from the court to the jury. You cannot
404.
find him guilty just because you have to find that he had it on this day. The fact that he had it before,
Yeah,
you
that gets to
cannot
his
find him
point,
guilty
though.
based on that. We have a jury that
But to me, that only distinguishes the date. It doesn't tell the jury that you cannot consider it for propensity of carrying, doing
Yeah,
the same thing on another day.
Yeah, it doesn't really address this point.
Yeah, the charge was a felon with a gun, not, and that in itself was as a enhancement charge for the other things, but it stood alone. Possession of a firearm while a convicted felon.
Yeah, and that's something they could just say, well, he shouldn't have had the gun in the video anyway,
Yeah.
so we'll just get him on that one. And even if we think that the girl might have been lying, maybe we think maybe she's only lying because he's been bad to her before. So let's get, you know what I mean? It can stack up. It gives you a way to convict on something that isn't really a consideration of what the state has presented and proven. Oh yeah, maybe the cat lawyer emoji. That'd be funny. That'd be funny.
Did not return guilty all the way down on the charged offenses. I mean, I don't think that there is, I mean, obviously the defense position is that this bolstered Ms. Pelcher's testimony that that the jury found him guilty based on this video. But if you look at the jury's verdict, it declined to find him guilty of reckless endangerment.
Which suggests they
Ms.
did not.
And it declined to find him guilty of ag assault and just found him guilty of assault. And I think that if you...
This is why I did this earlier. That to me suggests that they didn't think that he actually had the gun on the date in question.
Yeah.
Yeah.
Like,
Yeah.
lady.
Which goes to the appellate attorney's first argument. What the jury thought at the time.
Yep, and it's crazy because the appellate judges didn't seem interested in, they weren't interested in that argument, and now she's like making it more important.
Yeah.
Oh.
Yeah, it's also funny that now she's getting into the jury reasoning the way the appellate lawyer did.
And the defense attorney off screen is going,
Yeah. Oh yeah, that'd be nice if they panned out to see his face a little.
just the biggest smile over there at that table.
This is a great idea, Matthew says. Just fill the wall with judge expressions. It's a great idea. It might happen. I have to set up my printer, though.
Look at it, it really does not come down to an issue of credibility because it comes down to an absence of proof on the aggravated assault. We have Ms. Pelcher's testimony that she says that he pulled the gun out of his pocket and said, it's in the brief, I shoot you in your face, but never, points it at her. It's not pointed at anybody. So we have an issue there. We have a
past
proof
tense threat
that he's approaching the area holding a gun in the air, but he's not pointing it at anybody. There's no firing of a weapon. So I think that the way to understand the jury's verdict, obviously, we don't know because we don't inquire. But looking at this, I think there's a very strong case that the jury did not rely on this video to convict the defendant of the unlawful possession, that it relied on Ms. Pelcher's testimony, that it found her credible, and the defendant's up on plain error review. So even if it was, it's an evidentiary issue. It's one that defense counsel intentionally did not object to. He wanted this video to come in, or at least was very willing to to use it in his strategy. That was the crux of his defense strategy, was attack Ms. Pelcher's credibility, explain. You have more than just saying she is lying. She is lying, and here's where this came from. And he pieced the different pieces of evidence together as a vindictive ex-girlfriend who was mad at the defendant and had sent this video to probation to try to get him in trouble. And then she saw him and she called 911 and said, oh, he's got a gun. And she described the video and the gun because she knew he had it. And that was defense counsel's closing argument. That is not, there's no reading in between the lines there. That was what counsel said. So given that we were up on plain error, given defense counsel's failure to object, and the fact that we're talking about an evidentiary issue, it's the state's position that the defendant is not entitled to relief from the admission of the video. And that it was a reasonable strategic decision not to object, and even if it was deficient for counsel not to object, the defendant has not established a reasonable probability that the trial outcome would have been different had he objected, given what we can discern about the jury's feelings on Ms. Belcher's credibility.
I'm more convinced
So if there are
by
no further
her
questions, the state.
than by the defense.
Oh,
Yeah,
boy.
Now, regarding everything else, maybe not, but definitely the gun charge, which is
That's a significant one.
Yeah, it's a significant one. And she made a better argument for that than the appellate attorney.
Yeah.
And I think
that's
that
right.
matters because, like, in a decision, if they know that something's going to be remanded or something's going to be vacated, if it affects the other sentencing, then everything's got to be vacated. So,
Yeah.
to me, that question from the last justice, he might have already been working out the logistics of, if we reverse on this issue, what has to be done again. Because the sentencing may have been contingent on the max years coming from the charge that would be vacated, the count that would be vacated. So,
Ask this court to affirm the judgment.
All right, thank you, General.
and he only reserved 2 minutes. Oh, they got
Yeah,
the whole
but
thing.
all you have to
fancy.
do, I
Thank
agree
you, Raj.
with
If
opposing counsel.
I would die if he gets up there
And
says
quote her saying
that.
the things, yeah.
This
Yeah.
guy could.
if Your Honors, please,
This guy could retire and go into acting.
Yeah.
Like, I could just picture him in so many movies.
Judge Dyer, what's the name of the fluffy guy in Modern Family?
I
I don't know.
Someone in the chat might know.
Mm.
Yeah, was the weapons real? What if it was like the prop gun? Oh man.
if defense counsel's strategy was reasonable, then the judge would have granted a motion to exclude. Because if defense counsel's strategy was reasonable, then it would be demonstrable that they are different guns, and the judge would have ruled these are different guns. You cannot talk about different guns. The gun is excluded.
I think that's different than what you're arguing is different than what the state just said. The state said that not that this defense strategy was that are different guns. The defense's strategy was the only reason she's claiming he has a gun is because she knows of the video, that she had seen that. It wasn't this is one gun and this is another gun. The only reason she gave a gun, she said there was a gun and gave that description was because she knew of the video. That's how I understood the state's
And do you
reasoning.
agree
of
that
the
that's what the
strategy.
record shows?
And that I do, and that's the big problem. Because if I may, I wrote it down. The quote from the state's argument when my colleague said she told them about the gun because she knew he had it. Well, if you tell the jury in a felon in possession that the witness knew your client had a gun,
I did these crimes.
that's going to encourage the jury to convict your client of possessing a gun.
Yeah.
That's
He's so
not a
good.
good strategy.
He's so good.
Yeah.
Oh God, he kind of reminds me of Andrew. Actually, Andrew has the same cadence when he argues.
Oh man.
Andrew Fleischman.
Gotta run that back. And it's like he meets their confusion with something that would be more confusing if you don't agree with his confusion.
That's what the record shows.
Confusion.
And that I do, and that's the big problem. Because if I may, I wrote it down. The quote from the state's argument when my colleague said she told them about the gun because she knew he had it. Well, if you tell the jury in a felon in possession that the witness knew your client had a gun, that's going to encourage the jury to convict your client of possessing a gun. That's not a good strategy. You can't go to the jury and say, she knew he had a gun.
But if the trial
You're-
court says you have to convict him for having a gun that day, you can't convict him for having a video.
But the video is bolstering the credibility of. So let's take what the state's told you. The state has told you that the jury carefully considered what she said and rejected the portions of what she said, except for the portions that were. I see that I'm out
That's a
of
good
time, but if I
point. That's gonna
may
be a good
briefly.
Go ahead.
Rejected what they said, except for the portions that were backed up by the video. So if the video were not there, then they would have rejected the testimony. The video is what rescues that conviction from the jury's conclusion that she's not being, that there's no proof. However you want to consider it. The video is what rescues that. And the only reason that video is there is because nobody objected. And that's the problem, respectfully. Thank you.
Thank you, Counselor. Excellent arguments by both sides, good briefs. We appreciate that. We'll take it under advisement, render an opinion in due course.
Oh,
Next.
I enjoyed that one. I enjoyed
Yeah.
that one.
When you can
we had
quote
some-
opposing side, that's
I
a
wrote
good
it
day in
down.
court. It's a good day in court when you can quote opposing side for your argument.
Yeah, that was good.
Yeah. Now it is almost 11:30 p.m. here. I have work tomorrow. I have to do.
Work
I'm,
things,
I,
adult
I'm
things.
writing an off I fuck motion, and off I fuck.
Good to have you on, Nick.
Thank you. Thanks for having me on. And folks, Friday, 5 p.m. as always, a panel show over at my place, the Slightly Buzzed panel show.
You know it. I'll be there.
Yeah.
That's good.
Yeah. See you, folks. Bye-bye.
All right, Jim, do you want to do another video or do you want to read one?
Uh,
Because the Court of Appeals, it looked like, I think they're all in the same court, not different districts. They did
Yeah.
1, 2, 3, 4, 5, 6, 7 today. 7 oral arguments.
oh man, how long is this one? Maybe I could do one more.
They're all like 36 minutes.
I
I don't know any backing, but 3 of them start with, well, never mind. I think they're video person. There's one where the state of Tennessee is the second in the caption. Maybe that'd be more interesting to watch.
Yeah, let's do that one.
Okay.
Hey, Hunt.
So this one, oh, it doesn't have closed captions.
Ooh.
So, all right, this one is Vernon Lee Ivy, the state of Tennessee.
This Honorable Court of Tennessee is now in session. Please be seated.
Thank you, Mr. Clerk. Call the next case, please, sir.
Yes, Your Honor. Vernon Lee Ivy v. State of Tennessee.
The tiny
Morning,
water
Mr.
bottles.
Stone.
Good morning, Judge. And may it please the court, my name is Wesley Stone. I was appointed by the post-conviction court to represent Mr. Ivy in his petition for post-conviction relief, and that appointment has continued through this court. I do request to reserve 5 minutes for rebuttal, please.
Certainly.
I think in preparation for these arguments, I think that the important thing that I want to stress the most is paragraph 17 of the petition for post-conviction relief. Paragraph 17A
I'm gonna boost it a little.
provides ineffective assistance of counsel, and paragraph 17B sets forth the grounds upon which Mr. Ivy filed his petition for post-conviction relief.
Wesley Stone.
Mr. Ivy entered a open guilty plea based upon misinformation provided
Oh,
to
boy.
him by his trial counsel.
Oh,
I
yeah.
will go through each one of these provisions in paragraph 17B. The essence of the advice that Mr. Ivy received was that he could apply for probation in a situation where probation was statutorily unavailable.
Where, I mean, what is that, how is that set out specifically in the record? I mean, what was actually said or misrepresented to him? What, specifically from the record?
So from the petition, and then Mr. Ivey testified at the post-conviction hearing, and both of those support what is alleged in paragraph 17B of the petition. And initially, Mr. Hurst, trial counsel, came to Mr. Ivey and said the state's offering you 10 years at 35% to serve. They continued their negotiations. Mr. Hurst went and talked to the prosecutor, came back to Mr. Ivey and said that he and the prosecutor believed that he would not be sentenced any less than 10 years nor more than 12 for a total effective sentence, and that sentence in 17-737 would be consecutive. There would be a consecutive sentence regarding two other cases, 18-329 and 18-330. In that conversation, as bore out both in that allegation and Mr. Ivey's testimony, there is a discussion about probation. First, Mr. Ivey was a career offender on the D felonies, which put him at 12 years. So that automatically denied him eligibility for probation. But Mr. Hurst told him he would not get more than 12 years if, after making his probation argument at an open sentencing hearing, that it went bad. If it goes bad, you're not going to get more than 12 years. So Mr. Ivey at that point is thinking his maximum exposure at an open plea, based on advice of Mr. Hurst, is 18 years. And as the court's aware, he ended up with 30 years just in 17-737, and then 6, those two sentences running.
This is a random selection, Jim. I promise. I didn't.
Yeah, I see what you're doing here. 30 years, huh? Wow, 30 years based on a plea agreement that went wrong. Where have I heard
that
this
wasn't
before?
knowing and voluntary.
Yep, I see what you're doing.
I guess wild. But at any rate, I think it's important, and this is bore out in the
That's funny.
transcript.
I like his binder.
And I think it's important also to
Because
tell.
he was in another thumbnail. He argued another case today. So I wonder if his binder, like the separators, are for like each of the things he has to argue today. Because I think he argues at least 2 cases today.
Oh, really?
I think so.
The court that I do believe that this is one issue. I've identified it in the brief as 2, but it's one issue. And the issue is that Mr. Ivey did not receive the effective assistance of counsel because he was provided incorrect information. He was misinformed by his attorney. He relied upon that incorrect information, and that prevented him from knowingly and voluntarily entering this open plea. So going through each one of these sentences in paragraph 17B, Mr. Ivey wrote, and the proof bears out, counsel informed the defendant that the prosecuting attorney was offering a plea deal of 10 years to serve in the Tennessee Department of Corrections at 35% to be ran consecutive to a previous conviction of 6 years. This confirms that there was a conversation between Mr. Ivey and Mr. Hurst regarding settlement. It does invoke a range classification greater than standard range 1 offender because 35% relates to the multiple offender range 2. And then it also denotes that the consecutive sentencing as it relates to either Rule 32 or 4035-115. But that suggests total, both in 17-737 and the 2 cases that Mr. Corbin Payne represented Mr. Ivey on, that he would be facing the maximum sentence of 16 years. What Mr. Ivey was not told was, look, you're facing 3 felonies where you're subject to 12 years on each sentence. 2 with a release eligibility after serving 60% as a career offender, and 1 with a release after serving 45% as a persistent offender. And the court can stack all 3 of these sentences for an effective sentence of 36 years. You should break their arm off, shaking their hand, and take this deal now. The second sentence in 17B. Counsel then told defendant that after speaking with the prosecuting attorney again, that they agreed that the court would not impose a sentence of less than 10 years, but not more than 12 years.
The reason I was making that face, by the way, is because it's like your attorney's advocating for you to commit crime. Oh, goodness. And I did look, he argued at least one other case today. The other was for a Mr. Rogers. That's the one I was playing to get a picture for the thumbnail. And Mr. Rogers was convicted of doing some things. And I thought it was funny because it was Mr. Rogers.
The notes of settlement negotiations, Mr. Hurst is relying on what the prosecuting attorney is telling him, not doing his own research, and that he would, that Mr. Ivey expressed his concerns about what he had been told previously, and that Mr. Ivey was told that he would not receive a total effective sentence in 17-737 of more than 12 years or less than 10.
But am I correct that trial counsel didn't testify
That's correct.
at the post-conviction hearing?
That's correct.
So the post-conviction court, I believe, relied on the plea paperwork.
That's correct.
Oh, boy.
That set out, maybe, I'm not sure how specific, what did the plea paperwork set out with regard to the
In
potential
answering-
sentences, I guess I'll ask.
And in answering that, not only what does the plea paperwork say, but what is the colloquy like?
Right.
And what did the trial court say in taking the plea as far as potential sentences? I think
Yeah.
both of those things I'd like to hear about.
I could answer that question, I think, with one response. There was no proof about how plea colloquies work under Judge Sexton, Shane Sexton. But the record in this case bears out that Mr. Ivey was alone. It wasn't normally in the line of cases, and that, or line of defendants taking multiple pleas, as Judge Sexton normally did. But the plea paperwork supports a finding on its face that Mr. Ivey was properly advised. I don't disagree with that. All the constitutional rights, all of those things. What the plea paperwork doesn't set out, and I think it's important that the court look at the plea paperwork in cases 18-329 and 18-330. And what you'll find when you look at those is in the plea paperwork, there's no designation as it relates to offender classification. In those two cases, Corbin Payne's cases. In the 17-737 case, the one that's before the court now, there's also no offender classification. But what the proof bears out, and Corbin Payne testified to, and Mr. Ivey testified to, there was an agreement outside of the plea agreement in 18-329, 18-330 that Mr. Ivey would get 6 years. Likewise, in 17-737, there was no designation of offender classification, but Mr. Ivey is relying on his counsel in this case that he's not going to get more than 12 years and not less than 10. So I know that, and I don't want to get ahead of myself, that's why I reserved 5 minutes for rebuttal. I know that the state has argued that the record is incomplete because there's no plea colloquy.
Well, how can we evaluate this without the plea colloquy to know what the defendant knew or didn't know?
I think it's simple. I think the court can presume that the plea colloquy was done consistent and according to law.
What law supports the fact that we can presume that when we don't have the record?
Because there's a written plea agreement signed by Mr. Ivey, signed by the state of Tennessee, that colloquy, and we've not raised the issue of there's some deficiency in the plea colloquy.
But you're raising the fact that he wasn't informed, and usually part of the colloquy goes through, this is your exposure on each of these sentences, especially in an open plea. Do you agree to that? Is that what you're taking a chance on?
And during the trial,
Supplemental
during the
briefing.
post-conviction hearing,
Supplement.
the state of Tennessee asked Mr. Ivey all of those types of questions. So I think that, and he confirmed that he was, if I recall the record correctly, and the record speaks for itself, that the court went through what that possible exposure was. And I quite frankly have to tell the court that I've been throughout East Tennessee and some in Middle Tennessee, and the plea agreements that are used by the 8th Judicial District and the one that's before the court now is probably one of the more thorough plea agreements that I've seen in 25 years. So, but I think that the record.
But the colloquy is extremely, back to Judge Ayers' point, the colloquy is extremely important, because if the judge said to Mr. Ivey, look, this is an open plea, and I can sentence you anywhere from X to 30 years at this percent to this percent because you're a career offender or whatever, and he says that to him and then says, do you understand that? Mr. Ivey says, yep, I understand that. Then there's not much we can do, one, but we don't even know, without that, we don't know if that happened or what happened, so there's nothing for us to review.
I disagree that there's nothing for the court to review, and as the court is aware that post-conviction hearings are adversarial proceedings, the state was well represented by counsel.
But it's not the state's burden to prove.
I agree with that, but if the defense is that the plea colloquy nixes this whole claim, the state of Tennessee could have presented that, same as the state of Tennessee could have presented Mr. Hurst to testify. So, presuming that the plea agreement was,
But it's not their burden.
Yeah,
I agree with that.
You have to prove your factual allegation by clear and convincing evidence. So you have to prove that he was not advised of this by clear and convincing evidence. If I'm the state, that means I don't have to do anything. You have to put that on, and if all you have is your client's testimony and you're not going to bring a plea colloquy or counsel to bolster that testimony, then how do you meet your burden?
Through the testimony of Mr. Hurst, through the allegations in the amended petition.
The allegation in the amended petition is no different than your client's testimony, so that's the same thing.
Right, but that's how we established it. I mean, if we established that what is alleged in the petition, we established that, and that supports a finding that Mr. Ivey's plea was not knowingly and voluntarily entered, same as in the Grindstaff case. Same as in that particular case. And I'm not sure if, and we rely on Grindstaff in our case, but I'm not sure if the record in that case had a plea colloquy transcript either. He was misinformed. He was told that his trial counsel would seek probation when probation was statutorily ineligible, and he was told he would not receive a sentence of greater than 12 years. Based on those representations in 17-737, while he's got a bird in the hand 6-year sentence in 18-329 and 330, he entered his open plea in his 17-737, same as Grindstaff did in their case. And this court, I think the Supreme Court concluded that Mr. Grindstaff's he was misinformed as part of his plea because his open plea, he was statutorily ineligible for probation, but his counsel was telling that he was eligible for probation and he was going to ask for alternative sentencing. So I think that to analyze this case, the court does not need the transcript of the plea colloquy. The plea agreement's in the record, and the state has relied heavily on that in their response, but it's our position that the plea colloquy does not affect this court's consideration of whether Mr. Hurst was deficient in his advice or lack thereof, and whether, but for that deficiency, there's a reasonable probability that Mr. Ivey would have not entered this open plea, same as Mr. Grindstaff. So it's our position that the court does not need that plea colloquy transcript to determine the issue before this court. That's our position.
You're basically saying if everything was perfect in the guilty plea, as far as what was said about this, but the rub comes in before that when the lawyer told him something that he couldn't get or could get, and so that's where you're focusing your claim on.
That's correct, Your Honor. That's correct. I guess it's a two-step process. You got to go through what the plea agreement is, and then at that point, Mr. Ivey signs off on it, and then you go before the judge and do the plea colloquy. assume that everything is properly correct in the plea colloquy. Nowhere in the plea colloquy would the court that I've ever been involved in would say, but now what has your lawyer told you? And what, it doesn't become into that kind of inquisition or that investigation by a trial court.
Isn't that because that's not relevant once the defendant enters a plea and understands what the potential sentences are? I mean, anything that was talked about before is really not relevant if on the day the defendant enters his plea, he understands the crimes to which he is pleading guilty. He understands in an open plea what the sentence exposure is for those convictions that he's agreeing to. I mean, that's what's in the record, that at that point that he agrees to all of those things and he knew what he was potentially exposed to.
And I would add to that, and in 18.329 and in 18.330, he was also told by Mr. Payne, and I think Mr. Hurst was part of that global agreement, the record will bear that out, that he would get 6 years on those two cases.
That's not before us.
I understand, but my point is that while Mr. Ivey is negotiating these cases, he's told in one case he's got a bird in the hand. He's told in this 17.737 that he's got a shot at no more than 12 years, but probation potentially. And so based on that induced him to sign this plea agreement, believing what his trial counsel that he had before, Mr. Hurst had represented him before, was telling him.
Right,
So
I think you're out of time. I think you've answered my question. So unless you want to keep using your rebuttal.
I'm showing a minute 42 unless it's been reset. But that's our position to the court. I'll defer to opposing counsel, but it's our position that Mr. Ivey Mr. Hurst performed efficiently, and that but for that deficiency, there's a reasonable probability that Mr. Ivey would not have entered this open plea in 17.737. Thank you.
May it please the court, Catherine Redding on behalf of the state.
Hey.
I will admit to being a little bit confused about the exact issues that are preserved for this court's consideration. My read of the record suggests that the petitioner has waived his claim of ineffective assistance of counsel by raising it for the first time on appeal. As I read the post-conviction petition, I understand he is asserting in that petition the counsel was ineffective for failing to tell him that his charges exposed him to 30 years to serve. As I read the brief, I understand him to be arguing that counsel was ineffective for failing to discover that he qualified as a career offender for the Class D felonies and a persistent offender for the Class C. That to the extent that those are, to the extent I am understanding the briefs correctly and the petition correctly, that means that the discovery claim is waived on appeal.
Kind of different issues that are discovered, though.
But the defendant is not entitled to relief regardless of this waiver because he hasn't established.
Shouldn't she say, I would argue that that's the same discovery?
Yeah, probably.
And thus, that's this waive. But she framed it as different issues being raised and that she's not arguing that it's not part of the same, that it's not different discoveries.
Yeah,
because if it's different discoveries, it could be a renewed issue again, right?
Yeah, for sure.
Deficiency. To the extent we're talking about post-conviction trial counsel's failure to discover that he was a career and a persistent for certain of his conviction offenses, he did not call plea counsel at the post-conviction hearing to ask counsel what he investigated. He didn't offer any of his own testimony on this topic. And even if counsel did fail to investigate or discover, as I understand the brief, the petitioner can't show that this failure caused counsel's representation to be deficient when there is a document in the technical record. It's a letter from the state. It indicates that the petitioner is at least going to be a range 3 offender.
Well, so despite your confusion of what issue, let me ask it this way. What issue do you think would be proper before us based on the record?
None of them.
I think the issue that's raised in the post-conviction claim is waived because it's not briefed. I think the issue in the brief is waived because it wasn't raised.
Well, that's what I'm saying.
So I don't think any.
No, I didn't ask that correctly. I guess.
Of course.
I'm not saying you're not saying they're waived, but like, which one was set up in the petition / the hearing that you would think would be properly before us? Does that make sense?
Like, which one was litigated below?
Yes.
I guess that counsel didn't. It's hard. I'm not trying to.
No.
Be tricky.
I presume we've got an order from a PC court saying, here's what I found.
We do, and the problem with the order. So the post-conviction petition
Once
has
again.
A bunch of allegations. Says my trial counsel told me this. My trial counsel told me this, and then the only thing it's basically setting out facts. And then there's a sentence that says counsel failed to tell me that the court could sentence me to 30 years to serve. And then the post-conviction court just copies this paragraph. It doesn't say petitioner has raised one claim of ineffective assistance of counsel. He says trial counsel never told him the sentences were going to run consecutively. It's not as clearly set out as that. So it is a little bit difficult to discern. But to the extent that he is claiming that we're not actually talking about, well, you didn't do enough research, which is not supported by any proof in the record. And we're actually talking about trial counsel's advice to me about my sentencing exposure was just wrong. The petitioners also waived that. And due to my confusion, it kind of comes in as an unknowing guilty plea. But I think that the facts and the argument in that section translate. I think those are responsive to a certain extent. Because
What?
we have a
Sorry, I missed what are we wedding?
guilty plea, but I think that the facts and the argument in that section translate.
I still don't
think
understand what
those
she
are
thinks the
responsive.
issue was. Like, it seems like she's saying that the court below just cut and pasted the argument and then, kind of
Well,
blanked
and
it.
the way the paragraph that she read was written seems like it was written by what's his name, Vernon Lee Ivy himself, because it was like, my lawyer didn't tell me.
Yeah.
So it seems like one initiative to raise this issue was written by the person themselves, and I think courts should give deference if someone tries to argue something themselves and then an attorney comes in, whether one is on PCR and one is on appeal, like, I think that's an important factor.
Yeah.
And that's all I got from her pointing out that paragraph. So I don't think that really helps her.
To a certain extent. Because we have I think the petitioner hasn't proven his claim that trial counsel just didn't tell me, that his advice to me about what I was receiving was incorrect. Because we have only the petitioner's testimony. Obviously, it's going to be self-serving testimony because it's a petitioner testifying about what happened in his plea. We do have some testimony from the other attorney, but we don't have anything from trial counsel. Trial counsel was not presented. Trial counsel didn't say, yes, I told him, that's correct, that's what I told him. Or, yes, I told him 10 to 12 years, but I told him that it's going to run consecutive. We only have the testimony from the petitioner, and we don't have the plea transcript. So we don't know. And we don't know whether the trial court did as trial courts generally do and say, these are the charge, this is what you're indicted on. I understand you're pleading guilty here. This is your offender classification as this type of class range 3. You're exposed to this. Did you discuss this with your counsel? So we don't have the breakdown. We have the plea paperwork, and we have and the petitioner signed it, and he affirmed in that paperwork that he understood his charges. He had discussed his possible punishments with counsel, and he had reviewed the tables of punishments and parole release eligibility percentages. And The petitioner did admit at the hearing that he told the court he understood
interesting
his
clause.
sentencing exposure, that he was entering his pleas knowingly and voluntarily.
Because Georgia does, I mean, on the pleas that we've read, I've never seen that, but they include a clause on their plea forms. And maybe that's what the appellant attorney was saying. Like, this is a thorough plea deal.
Yeah.
And it says, I've seen the sentencing tables. Like, I've never heard that before. So that sounds
Yeah.
very thorough.
Yeah, I mean, it's just one of those. I hate when they do this. Like, everyone thinks they understand it, but like, it's an unknown if you don't know that you don't understand it. Saying, I understand something, and it's
You don't know what you don't know.
Yeah, exactly.
So I think absent, we have sworn testimony at a plea hearing that comes in via the petitioner's sworn testimony at a post-conviction hearing, and we don't have anything else. And I think the petitioner's, his sworn admissions in the immediate, right before he says, yes, this is what I understand, I want to plead guilty, I am pleading guilty voluntarily, I know what's going on. So we have that, and we have an admission from petitioner. And with that information, and without anything else, I don't think that the petitioner can prove his claim of deficiency. But I think his bigger problem, too, even if this court were to find that trial counsel, if the petitioner's testimony 10 to 12 years, you can request probation. If that's true and that doesn't line up with, 12 years is not probation eligible. If the court were to find that counsel was deficient in some manner in conveying this information to the petitioner's second problem is that he has to prove, because he pled guilty, that he would have a reasonable probability that but for counsel's errors, he would not have pleaded guilty and he would have insisted on going to trial. And the petitioner testified at the post-conviction hearing, well, what would you have done had you known? And the petitioner's own testimony was, if that he had known he was ineligible for probation, he would have tried to go back to the original plea offer. That is not insisting on going to trial. And then he says, had I known that the trial court was going to give me 30 years, had I known definitively that that was going to happen, I possibly would have gone to trial. Neither of those amount to, I would have rejected the plea offer, I would have insisted on my right to go to trial. And that's what a petitioner who has pled guilty has to show. So even if...
I disagree. By saying either of those things, you're still saying, it's still an acknowledgement that you gave up your right to a trial.
Yeah, I mean, you never know for sure. You can never definitively say what you would have done in a hypothetical situation.
The act of the plea is inherently giving up your right to a trial. The act of going back to another plea would put you back in the negotiation stage. You can't, the defendant can't just decide, I'm going to go take a different plea deal, because the one you're considering is the one that's on the table. That other one might not be there.
Yeah.
So going back to an old plea would mean you're in negotiations when a trial is still on the table. You'd be back in negotiations. So,
yeah.
Counsel was somehow deficient. The petitioner just has not shown prejudice as well. And that is kind of given the confusion, or at least my confusion, that is the petitioner's burden here to show prejudice in this manner, and his sworn testimony at the post-conviction hearing does not rise. It does not meet that burden. So if there are no further questions, the state asks this court to affirm the judgment of the
Is there any credibility finding by the court about what this petitioner had to say?
No, the court did not make any explicit credibility findings.
Theoretically,
yes.
Back to a point that my colleague, Judge Dyer, I think, was making, and maybe Judge Ayers. Theoretically, if Mr. Ivey files this petition for post-conviction and alleges these reasons that he was inadequately represented in their constitutional issues, and he puts them all in his petition and gets called into court, and the burden's on him to prove by clear and convincing evidence, factual allegations. So he testified, because this is pretty unusual with usually we have the lawyer who represented him, and so, but he testifies, the petitioner testifies, and there's no entry of the plea, any other paperwork except his petition. And he just says, this is what happened.
He has sailboats
Theoretically,
on his tie.
now, if the PC judge said, you know, I believe every word you're saying here, and I think this amounts to a constitutional violation of your rights, and I'm going to grant post-conviction relief. Next case. I mean, is that possible? I mean, there's no requirement that anything else. I'm not saying that's what happened here. I'm just curious as to, this has brought up some, in my mind, okay, what, are there certain things that we have to have in a post-conviction case every time in order to grant relief? It's a pretty heavy burden. Even if we have all those things, it's a pretty heavy burden on the petitioner every time. So what do you think?
I think it depends on the nature of the claims, right? So petitioners can, there are certain claims where a petitioner has to testify. And if the petitioner's claim was here, counsel was ineffective for not discovering something, you have to put on counsel to say, yeah, I didn't discover it, or no, I did discover it, or I didn't need to do any research. I don't think that this court has ever said that a petitioner is required to put on counsel. I think that there is actually a bit of a split. I think the majority of the cases suggest, and I will admit that I'm going off of memory, but my recollection is that most cases say a petitioner needs to put, is not required, but if trial counsel's testimony is needed, that it's the petitioner's burden. I do think that there might be one or a few cases that have said, well, state, you didn't put trial counsel on, so this is actually your problem. But I think that the majority of them say, if counsel's testimony is needed, it's a petitioner's burden. And I think that given, if the claim is discovery, failed to discover.
It'd be nice to have case names.
Trial counsel's testimony,
I think there's
testimony was necessary here. But I think going back to your question about whether there was a credibility determination, I think that there's no explicit credibility determination, but given that the post-conviction court was considering petitioner's testimony at the evidentiary hearing and then the plea paperwork, which is signed, I think that it could be understood that the court was making an implicit credibility determination. Like, I'm going to think your statements closer in time, or your signed plea paperwork, and the fact that you have affirmed that you've reviewed all of these things, that is more credible than what you're saying here now, that you have received a sentence you're not pleased with. So I'd be happy to research it. My recollection is that.
No, I was just curious. I don't think I've seen one quite like this before. It made me start wondering about it. So you don't.
I certainly do not recall. My office would have heard if a post-conviction court granted relief solely on a petitioner's testimony. So I don't know that has happened.
This PC court did not grant relief. I mean,
correct.
Yeah, but
yes.
I was just
but I don't know that there's any law that would prevent a court from doing that. But I think certainly here the issue is more that the petitioner has not met his burden, and certainly that he can't establish prejudice as we look at it through the lens of a guilty plea. So if there are no
Thank you, General.
Thank you.
Interesting.
Stone, rebuttal, sir.
Yes, Judge, thank you. Mr. Ivey testified that, as the state has correctly pointed out, that he would have tried to go back to that 10 at 35 naturally. I mean, who would accept 30 when you got 10 at 35? Makes no sense. And secondly, he testified that he possibly would have went to trial. That's what the transcript will bear out. Just to respond to some of the things.
I think that was actually a good point. It took me a minute to catch what he was saying there. But the point of him saying, because I think the state missed the point of the defendant saying they would have gone back to the old plea because it was way less.
Yeah.
So to me that shows state of mind that he didn't understand the risk, the timetables.
Yeah, that makes sense.
I didn't really
Just
catch. He came up here and said it so quickly.
Yeah, can you play it one more time? I didn't quite hear that.
Yeah. Oh, is he talking? I think he talks right away.
Mr. Stone, rebuttal, sir.
Yes, Judge, thank you. Mr. Ivy testified that, as the state has correctly pointed out, that
Correctly pointed out.
he would have tried to go back to that 10 at 35 naturally. I mean, who would accept 30 when you got 10 at 35? Makes no sense. And secondly, he testified that he
That's true.
possibly would have went to trial. That's what the transcript will bear out.
So I think I got to tune in more to when, as
Yeah.
the state stated correctly. Anytime I hear that, I've got to like listen better.
Yeah, that's funny. It's evident. Yeah, it's evidence they didn't understand that he got effective assistance, and they try to flip it. That's clever. Good argument.
Just to respond to some of the things that the state had said, what was litigated below, and I went back and counted these, and I'll say them for the record. There are 7 references in the 71-page transcript to a knowing and voluntary guilty plea. Some of those references were by myself, and some of those were by the state's attorney. So clearly the issue, to address, I think, Judge Dyer's question, was what was the issue that was actually litigated in the court. And what was litigated in the post-conviction court was the issue that he was given bad advice on 2 fronts. The state is telling this, and that's that he would get no more than 12 years, and that Mr. Hurst was going to ask for probation. The elephant in the room on this case is the 30-year sentence that he got. How did the court get there? So I mean, even in the
So the question you pose is the reason that there's a problem. We have no idea what happened at the plea hearing. And without that, how can we address any of this? I mean,
Yeah, this is
assuming
urgent, and it should be the record.
that counsel did say, hey, I think you can get 10 to 12 and maybe probation, and then they go to the plea hearing, we don't know whether the trial court said, as General pointed out, here's what you're charged with, here's what you're pleading to, here's your exposure, here are your ranges. Did your attorney explain that to you? And if your client said, yep, he explained all that to me, I know exactly what we're doing, then you have a problem. But without that document, without that record, we can't really review any of this.
I
It's not,
disagree
it's not
with
necessarily wrong.
and here's why. Echoing Judge Wiedemeyer's question about, are there certain things this court has to have in determining this issue? And there's nothing out there that says this court has to have
But a trial court at the end of a plea hearing at a plea colloquy, should make a finding that I find or don't find that this individual is entering their plea knowing and voluntarily. And that's what you're asking us to review. And so you're asking us to review whether it's a knowing or
Actually,
voluntary plea.
If they're looking for the judge's finding, I feel like that actually is on the state then to produce. I don't really think that that's what the appellant is making an argument for this issue. That would be something that would support the state. So why would that be part of the burden for the appellant to produce in the record?
Yeah.
If that would be a counter argument for the state to provide.
Yeah, I mean, it does seem like all the evidence in the record is favorable to the defendant or the appellant. And they're saying like there's not evidence to the contrary. There's an absence of evidence to the contrary in favor of the state. They're saying all the evidence is in the favor. They have the plea agreement, which doesn't accurately state the defendant classification. And then they have the testimony of the defendant in both point in the direction of ineffective assistance. They're saying you don't have the colloquy transcript, which would potentially remedy the ineffective assistance. So yeah, it seems like all the evidence is in the favor of the appellant. And
Yeah,
they're
and
saying
then
it's an issue that you don't have the contrary.
The final signature is just the someone signing off saying that they understand, but the fact at issue raised in this appeal is that he didn't understand. So I would argue that a signature that he understood, if you're saying he didn't understand what he was signing, that goes to the heart of the argument here.
Yeah, for sure.
And the reason the finding would be important is because you would assume that the judge has made a determination based on what happened at the colloquy. So to not even have the judge's finding, if he didn't say that specific line, I think that's a issue for the state here. Like, I don't know.
Knowing involuntary.
I guess you got to pull the transcript to show he didn't say it.
That's what you're asking us to review. And so you're asking us to review whether it's a knowing or voluntary plea without knowing that what the trial court did and how the trial court acted. How can we determine whether it's a knowing and voluntary plea?
Perhaps I'll sound circular in this, but that's not the issue of deficiencies within the plea colloquy are not before this court. And as Judge Wiedemeyer asked in my opening argument, it's the issues that occurred leading up to that induced Mr. Ivey to enter that plea agreement. That's the issue in this case. And with exception, I do believe that 18-329 and 18-330, the agreed sentence of that 6 years, while at a time he's going to an open plea like Grindstaff did, does create a little bit of confusion in his part that, oh, well, Mr. Payne, I've got 6 years on this at 30% range 1, but my attorney on 17-737 is telling me this. I don't like to be the lawyer on a case where new law comes out, and I'm hopeful that I'm not the lawyer on this case when new law comes out. But there is nothing that says that there has to be a plea colloquy. And now going back to Judge Wiedemeyer's question, the record is before this court of what was said. And I do believe that the trial court could have done what Judge Wiedemeyer said. Based on this testimony, this is the evidence before me. State, you could have called Mr. Hurst, stop complaining about Mr. Stone not calling Mr. Hurst, stop complaining about us not having a plea colloquy. You could have done all that. This is an adversarial proceeding. Mr. Stone's presented his case. There's clear and convincing evidence. Post-conviction granted, he gets a new trial. And that's what we're asking this court to do. Thank you.
All right, thank you, Mr. Stone. In general, we'll take it under advisement. Got one more case, I believe. Mr. Stone, you're on the next one too, aren't you? Mr. Clerk, call the next case, please.
Yes,
He did a bunch of those. That would have been this one. Which we don't need to stick around and watch. That ending stumped me. I mean, I don't think they're gonna go for it, but
No.
he to me, I would love to see some weight be given to when someone goes into a plea hearing. Who's gonna take the recitation and one, catch anything that might be legal jargon that's different from what they had face-to-face conversations breaking down with their attorney before the plea colloquy. Like, I think that's such a fundamental problem.
I agree.
And I know. And I think that's what he's getting at, and nobody wants to go there because they're just going to say, well, all of these other yeses happened at a later point in time. And he's saying, yes, exactly. All of that was subsequent to the initial lack of understanding. The understanding never got better.
Yeah, for sure. And I do think, I think in Georgia, the burden is on the state to prove that a guilty plea was knowing and voluntary. So there's not a burden shift. But yeah, I mean, there's just a better way to do guilty pleas instead of what they should really be doing is just asking the defendant, like, hey, what's your understanding of your sentencing exposure? What's your understanding?
And make them say it.
Yeah, because I mean, you don't know what you don't know. And I mean, I can make everything about Moontink, but it actually is useful here. In that case, you have one guilty plea. There were two guilty pleas, right? And there's less of an issue with one. But then there's another that's clearly wrong. It's clearly based on false information. It's not a knowing guilty plea by anybody, not by the defendant, not by the state. They just all blew it. not the defendant, but the lawyers, the judge, everybody had no idea what was going on.
It would have been great if you had that clause. I understand the timetables.
Yeah.
And then it was an illegal sentence outside the range.
Yeah. That would have been funny. But yeah, the state, they essentially said, look, you said you understood count 1 and therefore you understood count 1. But he also said that he understood count 30. And so they're using the same evidence, the exact same evidence on count 1 when it's proven to be false, useless evidence with respect to count 30. So it's just this practice of saying, do you understand? It's really just, it's kind of useless because, I mean, you think you understand, but you may or may not actually understand. So that could be eliminated by just asking people to, what do you think the allegations are? What crime do you think you're charged with? What sentencing exposure do you think
when do you think your
risking?
sentence will start?
Yeah, that's another good one. And just have them put it in their own words. That's how you measure understanding in any kind of system where you're really trying to evaluate somebody's understanding, rather than just sign this and you'll go home.
Yeah,
Shout
that'd
out to
be
my
a
boy.
great. See, and that's the kind. He's like, I don't want to be something for new law. I wish he said like, I don't want to be something for new law, but if it was, I would like to see something where we could show that the person can demonstrate that they understand at least the baseline of what they're giving up. If they're exchanging their right to a trial in exchange for this plea, we should take that understanding seriously. A simple yes or no isn't indicative of the understanding. So not to be the one to change the law, but if we do, make that a consideration.
Yeah, especially because Martina said, I'm a bit behind. It's scary how they really believe that everybody understands everything a judge is saying legalese. Did you read, understand, and sign paper ABC? Yeah, because you're also using your lawyer to, usually the written plea agreement, you're still having your lawyer explain it for you. So if there's any misunderstanding, it's probably going to trickle down to the thing. And when the judge asks, do you understand, that understanding is informed by the lawyer. So it's not like it's a totally neutral, separate process that, cleanses any misinformation you received previously from your counsel. You're basically just going to be, at that point, going along with what the judge says because you think your lawyer already worked it out. It's not like it's a backstop to attorney error, the way that I think they were kind of treating it here.
Well, and does the judge always, I don't know, I feel like I've watched some plea colloquies where they waive that stuff and then the judge isn't really getting into the risks and restating the timetables of what you're facing. But that's like quick little misdemeanor courts. Maybe I just tune it out. I don't know.
Yeah, I mean, sentencing can be complicated. Especially if you're no, I'm not gonna make that joke. Sentencing can be complicated. I mean, there's consecutive, there's concurrent, and sometimes lawyers just mix up the words. I've seen it before in cases where, how probation eligibility works, how much time you're likely to. There are just a lot of factors that go into it, and it's unlikely, I think, in most cases, that people like really understand the sentencing exposure. Yeah, Hannibal said having someone teach back their understanding new information or skill is how we do it in healthcare. Yeah, I think that makes sense. And frankly, it might even take less time to do it that way, because you can just say, instead of having the prosecution have to read through everything, they'll usually read the indictment. They not like literally, but they go through everything in the indictment so they can say that you understood it. You could just be like, hey, tell me the stuff, and then the defendant can say it, and it might actually take less time.
Wouldn't it be funny if they did an experiment where someone was hooked up to one of those was it EMG, the things that can show your brain activity and show like if you're tuning out and fading out while someone's rattling off their list of things that you're supposed to be acknowledging, just to make the point.
That's the other thing is you have like, especially in sentences, like sometimes you'll have cases where somebody has
a long list of a factual basis and acknowledgement to get through.
Yeah, and
we're
then
human.
Sometimes you'll have like 40 counts, and even if they're not all serious, you'll have like 40 counts, and they're all like a year or two, and the judge has to run some of them consecutive, some of them concurrent, and usually the judges can't even say it correctly without making some mistakes. I mean, they'll correct themselves, but
Or they'll
it's
even
just
say, let me
complicated.
stop and write this down, and they're taking notes, but the defendant isn't writing it down and following and tracking.
Yeah, especially when you have some counts that are concurrent and others that are consecutive, and you have blending like that. It's just,
I think it'd be a great thing to get right. Please keep the trial courts from getting clogged up. If everything else went to trial, we'd fail. We were talking about that on the earlier stream. And if we mess up plea deals, or people get afraid to take plea deals because they hear horror stories like this where, hey, everyone thinks, like, there could come a point in time where more people than usual are doubting the offer that's in front of them because they hear the horror stories of like Mung Tung situation or something like this. If you take this story at face value, which I don't have a reason not to,
yeah.
I think it's complicated, and I think a lot of people really don't know the repercussions of certain plea deals.
Yeah, for sure. I'm starting to think that people are going to start taking more stuff to trial, because I think that I think there's been kind of a crack in people perceived like trust of prosecutors. Not, I don't think it's going to change overnight, but I wouldn't be surprised if you see like 1%, 2% more trials, just because you have these high profile cases where you are getting acquittals. And
well, and then if people are weaponizing these, not putting a plea deal on the table, and you don't have bond,
yeah,
and then you get a plea closer to trial, but you've already served, and you're aware that you'd get time served.
Yeah.
The risk of going to trial and getting a sentence compared to what they might be offering you,
it's much lower.
Yeah, like, all right, I've already done 2 years. I'm here. I want to get out right now. I get it. But at the same time, if my max at trial is like 3 to 5 years, and they're offering me a deal to do another year in prison on top of what I've already done, like, why not just sit here and do it anyway?
Yeah, that gets into the whole bond versus no bond thing. But yeah, there was a guy, Contavious Jeffries in Fulton, about a year ago, and he had like, I think it was a double murder and a quadruple shooting, and he was facing like, he had a bunch of firearm charges. He was facing like life plus hundreds of years. And all the evidence that I saw was like Instagram pictures of him with like other people. He was probably in a gang, but like that's all they have.
That was their proof.
Yeah, he did 4 years in Rice Street, and then he pled out to ag assault, to a single count of ag assault. And I don't even think he went to prison. I think he was like it shouldn't have been a straight time served, but I couldn't find any record of him actually going to prison, like in the Department of Correction system.
Maybe they didn't send him because it was going to be less than a year's sentence. Like maybe they.
Yeah, maybe it was just in Rice. Maybe just did it in Rice Street, like another 8 or 9 months or a year in Rice Street, whatever it was.
Yeah, because if it wasn't more than 12, maybe they said let's not move him.
True, but it was like it's just such a ridiculous situation where, yeah, he probably could have beaten it at trial based on. I mean, here's the thing to me is like, if the prosecutors are willing to knock it might have been a single homicide or a double homicide. There were at least 4 people shot, and there was at least 1 person that was killed. But if they're willing to knock that down to ag assault, like you obviously don't believe in the case. You know what I mean? Like you should have just dismissed the case on your own or charged ag assault. You can't have a good faith belief in the strength of your case if you're willing to knock it down that far.
And I mean, it doesn't seem like they were exchanging pleas, because if he was supposed to testify against others, I feel like they would have moved him to another facility.
Yeah. I think the other guy, he did have a co-defendant, but I think he pled guilty first. And I think the second guy could have gone to trial like pretty quickly after that. But I don't think
the guy that was actually a better case for the charges ran and took the plea deal. He broke someone's arm to run and take that plea deal, knocked down on the courthouse door to take the plea deal first, and then they realized too late that the guy they had left for the trial was not the one.
Yeah, that reminds me of actually back to Moonsick, where you have 3 co-defendants and you have 2 co-defendants who give stories that are completely at odds with each other. They both plead guilty, and then you're the last guy. And there's the prosecution's like, yeah, we don't really know what happened, but like they both pled guilty, even though their stories are completely different. So, and
they both have to testify to the different.
Like how? Like you have to plead under Alfred at that point. Like, what else are you gonna plead?
Oh my goodness! Well, I love it. Everything comes back to Fulton.
Yeah, I mean, That's what got me into this mess.
Well, I'm glad it did. I think everybody has enjoyed meeting you.
Yeah, I like this lawyer. I think he had a tough situation without the colloquy. The guy on the screen, the little three
Yeah,
piece.
and when he got up, it seemed like he took over for someone that couldn't do the case anymore, couldn't do the appeals anymore. Not from the first counsel that was ineffective. And I'm pretty sure he got up and said the same thing for this guy. Because this is where I played out. You see the caption here, Mr. Rogers was convicted. Not Mr. Rogers. But I think he gets up here on this one, says he had to take over this case.
Yeah, Mr. Rogers has shooters out here in the neighborhood. It's Mr. Rogers' neighborhood.
Please support
Get it
my name is
twisted.
Wesley Stone. I was appointed by this court to represent Mr. Rogers.
Sorry.
His trial counsel moved to withdraw, I think, for personal reasons. I would reserve.
Okay, he did say trial counsel withdrew, so maybe it wasn't like a last minute, like appellate swap out. But still, he's just like inheriting these cases and out there fighting the fight. So I think that might have been an issue with him, like procuring the record, because plea colloquies should be transcribed, but are they not always? Do you have to bring a court reporter as the defendant?
I don't
feel like
know.
that's
In
something-
Georgia, they have to
I
be.
feel like that's something that any state should mandate, that a plea
Yeah.
colloquy should have a court reporter. So I don't get why we didn't just get the record. But
Yeah, that's confusing. Yeah, that's
if he came in late and the court reporter couldn't return it on time, then that would explain it. That's an explanation for me.
Yeah,
So-
for sure. Yeah, I think even that it should be stayed for or continued or whatever. But yeah, in Georgia, every guilty plea has colloquy, and you only need to pay 50 cents a page to download
that
that plea
specific-
colloquy.
I like that. I think certain other things should also only be that. I mean, do you know of anything else that's also like a maximum rate like that?
Oh no, I don't know if it's a maximum rate. I'm just saying that's what it costs. I was just complaining about how expensive PDFs are, even if they've already been paid for.
But is everything out, like if you wanted to get the record from a court reporter for other like days of a trial or something, would it be 50? It'd be more than that. So I feel like that 50 cent is a cap, that like a statutory.
Oh yeah. You're right.
So
Yeah, it
like
could be more.
I wonder what else also has that. Like we want to make sure that people can get this without it being too much of a burden, even though we're aware it's a service. So
Yeah, I think it might be everything actually on appeal. Now that I think about it, but not if it's like on Pacer, maybe or not Pacer. Odyssey. I don't know. Tiffany paid for everything, so you'd have to ask her.
shout out to Tiffany, the Fit Lawyer ATL.
She's got it covered. You have to ask her about that. But I know we didn't pay for all the appellate transcript stuff. Some of it
We've
was
got to
just-
get her on for one of these. We should start doing these.
She's so fun.
And like rotate who we have pop on. I will say that they do a lot here. The next one all look like civil cases. Like this might be a probate or something, like something
Yeah.
within a state, but everything else is at least two-party named. So these all look like civil. The 24th and 25th, which there's a Signal Pump versus Arrow Electronics. I wonder what they're fighting about. Let's see. This looks like groups fighting among groups. Let's see.
Man, I'm on Twitter, and Noah Pines correctly basically said to the calling guy that that Cruz needs to get off the case.
Withdraw.
And he's completely correct. And I kind
It's
of want
only
to
been a
retweet
day.
him.
It's only
He's-
been a day.
Yeah, but he really does need to. And I love
And
Noah.
I mean, he's
because-
not going to file a motion to withdraw before sentencing.
No.
So, I mean, I don't think we're all impatient. I think Noah is hinting that he wants to argue something in that case.
I think he's the best at like, or at least the most experienced with rape appeals. That's kind of his specialty, or at least one of his specialties. I mean, he's just generally good appellate attorney, but he's done a lot of them recently. And
Right.
he would be on my team of people if I were him, if I were Faust.
Well, I mean, I know everybody's been asking about fundraisers, so I mean, I really don't know how that works. Like, if you take on the case, the court could still appoint you and let you file for, because Faust is already declared indigent. So I know that you could, volunteer to take on a case, and certain things will be appropriated by the court still. Even if you voluntarily choose to come on, there's still some compensation through the courts. But however that works outside of that, I mean, I want to see a good, I think there's so many grounds that could make for not just issues as a matter of law that were issues at the trial that could get a new trial, but issues that I think should be considered by a court of appeals or the Supreme Court of Georgia.
Yeah.
And see new case law or clarification on certain things. And if we've got to take the time to appeal anyway, I mean, why not have someone up there that will make arguments for such a thing?
Yeah.
So
Yeah, I only have 30 days, so well, from tomorrow. I think it's the Monday, actually. So it does have to move somewhere.
Well, not that I'm doubting that the judgment will be entered right away, but isn't it 30 days from the entering of the judgment?
Yeah.
So I'm sure Lisa Lott will, before she leaves, she'll be like, rather than rely on the date of sentencing. But if she doesn't do it tomorrow or this week, they might get a couple extra days.
Yeah, for sure.
But man, I'm also excited to see Ahmad Cruz, how he looks in a few years.
Yeah.
Like very, very, to me, he's like BS can't get past him. And I think that that's something that some trial attorneys, they're very intelligent, but the common sense, they can't deliver. They can't say out loud why the stuff doesn't make sense. It just doesn't make sense. Yeah. Some very intelligent people can't deliver that like you're having a face-to-face conversation. And I think he's very good at that. So if he hones that in, he'll be fun. He'll be really fun to watch, I think.
Yeah. So. I think he needs to like develop his own style a little bit because he still needs to, he's a little bit of seasoning. Like the Steele impression was a little premature. You can't do that on day 2, but
he's got it. He should watch some Hedrick.
Yeah, Hedrick's good.
He can get the delivery. So with that being said, I mean, I don't know if this would be up your alley. I'll look for any other cases. We could also read next time you want to. I don't know if you want to set a weekly day, but
yeah, I just
hit the notification bell, guys. That way, whenever we do these without planning, you'll know that we're doing appeals court stuff. So.
Yeah, we still need to do that Warren King thing, the Butts County habeas, and we still need to do the Steele watch along from the
when he was the brunette or the male version of being a brunette.
Back when he was Brian Bronze. Brian Brown, I guess, was right there.
Oh, hilarious. All right, guys. So who knows when we'll be live for another appeal thing. Sentencing for Foss is tomorrow at 3 p.m. Eastern time. So I think the judge did that to make sure statements wouldn't run forever because court shuts down at 5 unless they stay late. So it's kind of weird, right?
Yeah.
You'd think a lot of people would have plans to speak at a high profile case like this, but we'll see. So
yeah, I don't know if there's like even a need to hear. This is going to sound cold. I don't know if there's even a need to hear much in the way of like victim impact, just because it is pretty much a fixed sentence. It's not like a. I mean, I guess
it's going to be life without parole and whatever other math that they put in there as a formality. Really, it feels like to me. I get that there's a reason for it in case like one thing gets vacated or whatever, and the structuring has to be done. But to me, it feels like a formality once you say life plus anything.
Yeah, exactly.
But yeah, life without parole, and I think the judge wants to hear people speak. I think she. Yeah, I think she liked. The
I'm sure they will.
It all.
I'm sure they will. Yeah.
So
I wasn't saying they shouldn't be allowed to. I'm just saying like it doesn't really.
And likewise, I imagine people will speak on Edric's behalf as well. So hopefully we don't see any restricting of that outside the bounds of like what would be relevant.
Yeah. Victim impact statements are kind of a weird philosophical thing anyway. It's kind of, it's like a very law school thing, but the thing is like, this is kind of like the philosophical question is like, should somebody be punished less severely if they murder somebody that's completely helpless and have nobody in this world who cares for them, as opposed to killing somebody does have people who care about them? Like, is one more morally blameworthy than the other? That kind of never made a whole great deal of sense to me. But I guess it's for the well-being of the victims rather than anything else, which is fine. But philosophically, it's kind of Interesting.
if we're gonna do it, just keep it at the end after the conviction.
Oh yeah, yeah.
Keep
yeah,
it after
for
the
sure.
end because sometimes it seems to seep into pretrial stuff and bond hearings and you
Yeah.
know, I don't understand at a bond hearing unless there's like a witness that feels threatened, how there's a relevance of someone like a victim impact type statement. Like,
Yeah, for sure.
so
Yeah, it's messy. I think that's kind of been a trend in the last
Yeah.
few decades. Is
I
like
think because
more.
more bond hearings are being televised, and I think allowing it, you know, the judge just feels like it'll help me justify to the public. I've got to deny this person bond, and I just don't think that's the pathway we should be going. You know, transparency at a bond hearing should have nothing to do with changing the structure and purpose of a bond hearing.
Yeah.
So, but oh well, what do I know? Jim, thanks for popping on. Always like I write Jim last minute and I'm like, do you want to go do appeal arguments? And he's like, yeah, sure. Let me get a coffee. Let me get water. Here he is.
That was like 5 hours ago.
Yeah.
That's funny.
We've done 2 panels since then. So whenever we do this again, hit the bell, you guys. That way you can watch. Hit the like button wherever you are watching. And who knows? Maybe we'll be in Tennessee next time. Maybe we'll be back in Georgia. Maybe we'll find like Ohio. You never know. We'll hop around. Take care, everybody.
Yeah, bye, buddy.